welcome. Good morning, everyone. As Daryl said, we're thrilled that you're all here. Your attendance means so much to us, as does your participation in these sessions, right? This is a summit. We all want to learn from each other, so please, participate in the sessions. And for all of our first-time guests, a hearty welcome. And for those of you who return each year, thank you very much. It means a lot to us. Okay, so this is Buckle Up. I try to run through an update, which is very difficult to do because, as all of you know, it is almost overwhelming to keep up with all of the privacy issues that are going on. So I have to sort of cherry pick and present some. So I have to read this, right? Nothing in this document or any presentation using this document is offered as or to be considered legal or other professional advice whatsoever. Legal and other professional advice is prudently rendered only after appropriate factual development and related consultation. In this presentation by me is neither conducted, offered as, nor intended as any kind of consultation or other legal or professional service whatsoever by me or my law firm. This is education. No attorney-client relationship is offered or formed with me or my law firm, either by or through the delivery of this document or by the use of this document in any presentation by me which you attend or in which you participate. Thank you for your patience on that. Okay, so buckle up. Again, there is a lot to cover, and I really mean it. This is how you're going to feel. I say it every year. So this year I'm going to start with the state privacy landscape. And we'll talk about the federal landscape. We're going to start with the state because there's been a lot of development. So we have 5 states, those in green, that are coming online this year. One's already come online in January in California, and the other states coming on as we go through the year. Now, California technically came online with their comprehensive, that's what we're talking about here, comprehensive data privacy legislations, modeled to some extent on the European Act, the GDPR. California had a statute that they passed, it's been in effect for a couple of years, but the California Privacy Rights Act significantly amended that, and it became effective January 1st and will begin to be enforced July 1st of this year. I want to mention this just in case you don't make it to the workshop. You'll hurt my feeling if you don't make it to the privacy workshop. Because I think this is an issue that is slipping under the radar somewhat. The GDPR and the CPRA, which is the California statute, right? Both of these statutes are blind to the concept of business to consumer or business to business. To the GDPR, it's just personal data. So if you, in dealing with your suppliers or your consultants or whoever you're dealing with, right, your customers, and it's a business, it's an entity. You're thinking, this isn't an individual, this is a business I'm dealing with all the time, right? That name, email address, phone number, that's personal data under the GDPR. It's likely you have to have a lawful basis to collect it. It's likely because it's legitimate interest, which is one of the 6 categories, but maybe it's because you have a contract, a supplier agreement or consulting agreement, whatever it is, or you have some sort of, maybe even more than that, you have some sort of express consent. In the green there, the California Privacy Right Act, there were exemptions for both the business and employee, and that all expired. They did not renew those exemptions as of January 1st. So what that means is, again, the CPRA, like the GDPR now, is blind to whether it's a consumer relationship or a business relationship. So for those of you who are thinking, wait, I do business with people in California, or maybe I do business with people, in Europe, right? At least for the CPRA, the trigger is, does your business have 25 million annual gross revenue? And if you're smaller than that, do you annually buy, sell, or share personal information on 100,000 California residents or households? So that's the trigger. I'll also tell you, sell is very broad. It's not what we would think about as, oh, that's a sale. It's disclosing any information basically is a selling under the CPRA. So in the yellow here, I ask you these questions, right? Do you have any suppliers, consultants, service providers, strategic partners in the EU or in California? What's in your Outlook contacts? What's in your accounts payable system? All of that is personal data or personal information covered under the GDPR or the California. And for the GDPR, there's no like triggering threshold. It's one European resident, you're there. So, and obviously if you have any customers, right, your Salesforce, whatever you're using for your CRM, right, I'm not pushing any products here, in the EU or California. So to sort of drive home the point, Virginia, Utah, Colorado, and Connecticut expressly excluded business-to-business acquisition of those contacts. So those are not in that database, and they don't go to counting toward the threshold to see if you're triggered and now regulated under one of these 4 state statutes. I can tell you that the New York pending statute, and it's pending, so who knows what will go through, also expressly excludes business to business. They frame it as a person known to be acting in a professional or employment context. So again, if you don't make it to the privacy workshop, I at least wanted to get that message out, because I think a lot of businesses are thinking, I don't do business with consumers. I don't have any exposure under any of these privacy statutes. So it's to sort of raise the consciousness and think about it. Here are the statutes, the effective dates. The CPRA is effective January 1st. Virginia and Colorado come on, Virginia, Colorado, and Connecticut come online July 1st, and Utah December 31st. The Virginia, Colorado, Connecticut, and Utah statutes are highly similar. They also take off of the CPRA, which takes off of the GDPR. The GDPR being the most restrictive and widest protection, CPRA less, and then to some extent less with the other 4 statutes. So just to give you an idea of, well, maybe you never even heard of the California statute, or what does it mean? What are these rights that are now coming in this comprehensive data privacy legislation? Is to give your to know what's collected. They have the right to know what's in there, and they have the right to access what's in your database, to know what is sold, shared, or disclosed for a business purpose. And again, sold and shared are defined terms in the statute, and they're very, very broad. They have the right to delete. If you want to, like the right to be forgotten, like there's some exceptions to that, but they have the right to correct. They have the right to limit the use of sensitive, the definition of sensitive personal information, which in some ways is maybe a little broader than the GDPR, which also has a sensitive definition. You have to opt out. They can opt out of the sale or sharing of the information. You must give them that right and give them a way to exercise that right on your website and other ways, including a phone number. And you can't retaliate if they opt out. So you can't price discriminate unless there's some other reason to do that. But you cannot retaliate against anyone who decides to opt out of these things. So again, come to the workshop, and we'll talk more about these things. Privacy policy, and again, if you don't come to the workshop, these are incredibly important. And while you have these 4 statutes in the states, and then GDPR, which you can end up being subject to that if you're doing business with Europeans, then you could have some privacy policy issues if your privacy policy is deceptive. The FTC has been very vigorous in its enforcement over deceptive privacy policies. You have the exposure under the CPRA and also the GDPR for that. And so what should be in your privacy policy? Well, come to the workshop. That's what we're going to run through, like what's supposed to be in a privacy policy. And by the way, all 4 of these state statutes require you to have a privacy policy, as does the GDPR. But I will say, if you don't come to the workshop, just don't, copy paste somebody's privacy policy into yours, because that's probably setting you up for some misrepresentation or something, even though it wasn't intentional, because probably what that privacy policy says is not what you're doing, right? You have to do your own homework. You have to go through your own systems to figure this out. Okay. I'm going to mention AI. It's the only time I will mention it, although there'll be something at the end of the presentation by one of my students. I'm calling this the iceberg. I think it's the gorilla in the room, where, well, let me just say, inferences, profiling, automated decision making. These are sort of all, if you think of the iceberg, like all underwater, right, out of sight. All of this is going on, and the GDPR already has provisions. The data subject, that's the individual or someone who could be an individual, has the right not to be subject to a decision based solely on automated processing, including profiling, which produces some sort of legal effect. Insurance, employment, and there are a lot of others, right? The CPRA has a definition for profiling. It actually doesn't have a definition, though, for automated decision making. However, the CPRA has given the regulator, there's a new regulator in California just for this, the California Privacy Protection Agency. It basically gave them a blank check and said, go define what automated decision making is. Come up with the rules for it. Tell us what we should be doing, like how much of it, because there's this sort of grand bargain, that's how I've heard it phrased, between all of us who have had all these free services, free, right, giving up our data, all these years, and now a lot of this is disrupting that, mainly because the model is moving so much to these AI systems, as I call it, the iceberg, in the background. The other thing I'll mention is NIST, and most of you are familiar with the NIST cybersecurity framework. Just this year, 2 months ago, they released an AI risk management framework. I kind of looked at it a little. I haven't gone through it, and a lot of other sources. So I highly encourage everyone, if you have the time, these guys, NIST, they're very good at what they do, and I encourage you, if you have the time, to look at it. So my last comment here is, I'm not sure that we're talking about all these privacy issues, and they're important, but these AI issues, I'm just not sure that we're not sort of arranging the deck chairs on the Titanic while these AI systems are coming online. And they're here, right? This isn't the future. They're here, and they've been here. And you'll hear about one of them a little later. Okay. So let's talk about the feds, right? So if I go back to the map, if you can remember, why are those states coming online, right? Those 5 states and many others who are coming on. Because the federal government hasn't addressed this issue in probably 7 or 8 Congresses. I've been tracking this for a while. Congress, 2 years, right? So 14, 16 years, probably longer. Proposed every year. Cambridge Analytica, Sony. It's not me, is it? Target, right? Equifax. I mean, think of all the huge issues. Sorry, that is me. My brother calling. All right. But the family thing, but he's in the family thing. I'll let him through. Okay, so anyway, all those episodes, think about them, right? Didn't motivate. Colonial Pipeline, right? Probably, didn't motivate. Is it going to happen this year? I don't know. President Biden, right? It's time to pass bipartisan legislation to stop big tech from collecting personal data on our kids and teenagers, ban targeted advertising to our children, impose stricter limits, right, on the personal data that all these companies are collecting on all of us, right? So we had the American Data Privacy and Protection Act, so comprehensive federal legislation in the last Congress, right, which ended in December, right? 53-2, heavily bipartisan, dealt with the issues, including 2 big state issues, which is, will the federal legislation, comprehensive, override, California and all the other states who are in this, right? And a private right of action. So you're not just relying on the FTC to protect you, right? Give everyone a private right of action enforcement. And so they agreed on all that. They passed out the report, but, Congress ended. So now we're in the 118th Congress. I haven't really seen that bill like somewhere pending. I assume it'll be put into something at some point. Right now, there's this Data Privacy Act, which doesn't really deal with it. There's this other thing in the Senate that deals with only health and online location. And a few of you have heard me in the past talk about how HIPAA, we have these silos of statutes, and HIPAA and Fair Credit Reporting Act that deal with certain issues, but we don't have one comprehensive like the GDPR. And so while health information, if it's a covered entity, a clinic or a hospital, something is covered under HIPAA, if you swab your mouth and send it off to one of these genome companies, they're not a covered entity. Even though that's health information, that's not covered under HIPAA. And so this Senate Act is a way to sort of begin to regulate some of that. Even though there is some biometric provisions in some of the statutes, this is at the state level, this is specifically at the federal level. We're also trying to amend the Children's Online Privacy Protection Act to let children purge whatever was collected on them before they were 13 years old. And there's other bills pending as well. I'm going to also talk on the federal level about the Cybersecurity and Infrastructure Agency. In fact, I'm going to talk a fair amount about that. I'm going to talk about the FTC rulemaking, and I call it the big dog has now barked, and they're ready to guard. And I'll talk about the Privacy Shield, the GDPR, and we're sort of now in round 3 of trying to make a deal between the United States and Europe on how to have the data cross the Atlantic. So let's start with CISA, Cybersecurity and Infrastructure Agency. It's in the Department of Homeland Security. It was established 5 years ago. There was a program inside of there for many years, but it only focused on federal assets, right? Protecting the federal assets. And what happened with this new agency was to say, you know what? We're going to make this robust role in assisting the private sector and state and local government. So a cyber watchdog for everyone, not just the federal assets, right? And they were originally not a regulator. They were really cast as a partner, a lot of voluntary provisions, nothing, as I call it, carrot and stick. It was all carrot, no stick, right? Today, they are really a regulator or regulatory-ish because of the statute that I am going to talk about, but they're still a partner in many ways. They have 2,800 employees, a $2.9 billion budget, and some people have called them America's top risk advisor on cyber. And they label themselves as the America's Cyber Defense Agency, even though that's not their legal name. So I have to take you back in time so I can talk about the recent things. So back in 2015, before there was the CISA agency, right, there was this, which is a little confusing, the Cybersecurity Information Sharing Act, also known as CISA, right? All about voluntary, no requirement to share. And the point of this, and it was radical in a way, for private sector and state and local government to share with any Fed and each other. So there's a mechanism. If you want to sit down with your industry peers and exchange information about the threat vectors or whatever it is that you're worried about in your industry, this was meant to be a way where you could do it without the Fed even being there. To gather together, talk turkey, figure out what the issues are. And as we go through, I'll show you. You could even disclose personally identifiable information in that if it helped the conversation, because there's a shield of liability for you disclosing that information in that context. So it was to try to give you a free, open, transparent forum to talk about these issues in your industry. And this has been around since 2015, right? And some of you may participate in the program. So the goal was to encourage robust sharing, establish sharing type and means. So the two things are defined terms: cyber threat indicators and defensive measures. Those are the two things that you can do and enjoy. So the carrot approach, they give you this liability shield, so notwithstanding any other law, federal, state, or local law. So you end up sharing some personally identifiable information in there, supposed to shield you from any liability under all these statutes we've been talking about. There's something called the Automated Indicator Sharing Platform. So you contribute your information, and then you get to receive, it's like a clearinghouse, but it's sort of anonymized or purged, redacted in some way so you can't really see certain information, right? No cost, partner concept, and there's also some other means, some web form, other ways to get in. So again, there's an antitrust waiver. So you all get in the room with your competitors and talk things. Usually the antitrust lawyers, I do a little bit, are like, oh, don't go do that. That's not a good thing. You're colluding on prices or whatever, right? You get a FOIA waiver. So there are all these FOIA statutes, Freedom of Information Act, whatever you share in that, someone can't come and say, well, wait, that's, the government was in there, local government or the schools or whatever were in there. We want to know what all that is. The big exemption to any of that. All your attorney-client privileges and other privileges that lawyers worry about, trade secrets, all these things are supposed to be protected. And there's even a self-snitch thing where even though you're talking, and you're maybe disclosing to a federal agency, that's not supposed to be used against you by another federal agency who is maybe regulating. Now, if that other federal agency knows about it anyway, okay, that's a different issue, but not because you were participating in this protection program, right? Because the whole idea here is to get all of us talking together to stop these threats, right? That's the overall concept. So, and there are some other provisions about how much personal identifier you even have to remove. I'm going to run out of time here. So its sharing is not a substitute for the agency. The defensive measures are truly defensive measures. It's not about sharing hacks, like penetration hacks, like offensive things. It's all about just sharing your defensive ways. And you can't share with, a foreign power, right? So you don't go share with the Chinese or the Russians. So there's a whole bunch of free services that they have, tabletop exercises, all sorts of things. It's all part of their partnering concept services, so you can sort of check that out. So why am I talking about that? So a year ago, we got the Cyber Incident Reporting Act. This is where the CISA sort of turned into a little more of a regulator, right? This is requiring you now to report covered cyber incidents within 72 hours to this clearinghouse now, right? And ransomware payment. And to be clear, the ransomware payment obligation is independent of whether it's a covered cyber incident, because that definition might leave out some cyber incidents, but any ransomware payment that you make, you now need to report to these guys. So the good news, I guess, is it's not yet effective. They have to go through some rulemaking, and they've started down that path. The impact, really, if you're listening, is more private sector investment in cybersecurity, maybe underinvested to date, no more plausible deniability about whether you had a hack or not, right? And what do you want to do now? If you don't have a chief information security officer, probably want to think about hiring one, and should that person directly report to the board. So who are covered entities? There's 16 sectors. They're laid out. You can go to the CISA website, and there's details on every one of these sectors. I'm just going to talk about one here, but where we are here on the river, right, and a tourist attraction, right? All these chemical facilities, other government offices, but also, if you look at the commercial, entertainment, motion picture, casinos, right? The Superdome, right? The arena, right? The convention center. All of these are deemed to be in the sector and critical and vital. So all these assets are part of it. So that's the definition. When you get the PowerPoint, you can look at that. It's the presidential policy directives where they come from. So a cyber incident is a group of an individual or related that results in demonstrable harm to the national security interests, foreign relations, and this is, or to the public confidence or civil liberties. So that's pretty broad, might not take much to shake us on some of these, right? Ransomware. Very broad. The transmission of any money or other property, including virtual currency, right, or any portion thereof, which you paid, delivered as a ransom in connection with a ransom. And you must report that even if the ransomware attack is not, as I said, a covered incident. So you got all those same protections that you saw in the 2015 statute. They're pretty much the same here, right? Liability shield, no discovery, use at trial, the FOIA waiver, the privileges, all these things are there as part of still the carrot, concept, right? We want everybody to start reporting this information. As a nation, we need, that's the concept. We need to have this clearinghouse and single collection point for all this information. And there are some self-snitch concerns in there, but they try to address them the same way the old statute does. I will mention here the Office of Foreign Assets Controls, which you may have never even heard of, right? What do? They're in the Treasury, and they don't want you paying bad foreign actors. They don't want you paying these cyber criminals in Russia or China or wherever they are. And if you pay them or facilitate the payment, you're violating their laws, and there's civil penalty, whether you know it or not. Even if you don't know where the payment's going, maybe the federal government can track it. So that's what we call in the law strict liability. Whether you knew it or not, doesn't matter. Were you part of a payment, made a payment, part of a payment that went to one of these bad dudes, you're liable under the OFAC guidance. And there's a guidance, you can go look at it, because they're trying to say, if you mitigate with us, if you come to us, if you tell us things, we'll take that in consideration when we're figuring out how to sanction you. There's warnings, there's things short of money, but there are, money penalties too. So they don't want you to pay ransom. That's basically what the government's saying. So you've got 72 hours or 24 hours for a ransom payment. It's not yet effective. The rulemaking is going on. There was a notice of rulemaking, has to be finished by a year from now. The rule has to be out there for public comment, and the final rule is 18 months after that. There was a request for information that they put out in September, and that's closed, and so they're doing whatever they do as regulators to try to come up with the final rule. So, use this time. Maybe you got 2 years, maybe you got 2.5 years, maybe you only have 18 months if the government does what they typically don't do, which is move fast, right? Use this time to ramp up, invest in cybersecurity, and onboard your CISO. They have subpoena power. I don't have to go into all this. Even the head of the agency says, we're really not law enforcement, we're not a regulator in the traditional sense, but they got some enforcement powers now, although they refer everything to the Department of Justice for enforcement. Okay, so that's most of CISA. I'm going to this because most of you are familiar with this. This is the very comprehensive NIST framework for doing your assessment. Anyone who's walked through this knows how comprehensive, detailed it is, right? CISA said, that's overwhelming, especially to a lot of small and medium-sized businesses. So in October, they put out something that they call cybersecurity performance goals, right? And they call it a subset, an abridged subset of NIST. They're basically saying, hey, you smaller businesses out there, you might want to go look at this and at least try to walk through, this set. And it's all the forms. It's very form related, and you can do it. So that's CISA. Okay. Let's go to the FTC now, right? I've always called the FTC the big dog. They have enforcement powers just generally under deceptive and unfair acts. They do consent decrees against people, get them under 20 years under their thumb, right? And they've been very active in the privacy space, right? They've been using these consent decrees to create a common law of data privacy rights, but it's hard to clearly define those rights just when you're dealing with this episode and you get a consent decree and you deal with this. It's not really comprehensive, right? It's just sort of putting out the fires, right? And so, is there a need for a comprehensive federal statutory regulatory regime? Most people would say, absolutely. Well, the FTC is saying, I'm not waiting. I'm not waiting for Congress anymore. I've been begging Congress for probably 6-7 years to do something. They haven't done it. So now the FTC has put out an advance notice of proposed rulemaking. That was on August 22nd. So they're moving forward to regulate. They're the big dog, they barked, and they're ready to guard. So it's called the Commercial Surveillance and Data Security. And why are they doing this? I think unofficial, because Congress is asleep at the wheel, right? Why officially? Because they want to know, hey, is this the prevalence of commercial surveillance and data security practices that harm consumers? Should the FTC implement new trade regulations, right? Because they are unfair or deceptive. They have to say those things because that is their authority, existing as authority for years and years, to deal with issues that are unfair or deceptive. This is from it, whether we all know it or not, we're giving away all our data, right? They've been they call themselves, for 2 decades, they've been the nation's privacy agency. There was a hearing on the 25th. There was comments. They extended that to November 21st. This was a 3-2 vote along partisan lines, right? There's a dissent. If you want to go read it, the dissent's interesting too. And so we're now waiting for the FTC to draft and issue rules for public comment and rulemaking. So those will be significant because maybe that's going to override a lot of what we think about for privacy policies and practice. This proposal had 95 questions in it that they put out and it's interesting just to read the questions if you want to know what the issues are just by reading them, right? How should they balance cost and benefits? What about collection use, right? Automated decision-making, consent, notice of transparency. What about children, right? We want to talk about children expressly. So, and by the way, the FTC still has all their actual, they're outside of their unfair and deceptive. That's all the bats over there. They've got all these other authorities under some of these other data privacy statutes. Okay, that means I'm running late. Privacy Shield, right? We're now in round 3 on that. Google Analytics, just to show you, there is no Privacy Shield getting information across the Atlantic, right? Austria, France, they told, hey, if you're using Google Analytics over there on your websites and you're transferring data across to the Atlantic and the US is not approved, we don't have an adequacy decision with them, so that's illegal. That violates the GDPR. It's going on, President Biden issued a directive to basically to tamper down the intelligence agencies, which is really the problem, the Snowden leak, right? And say there needs to be a way to sort of put in more controls for civil liberties and to have a data protection review court that's now established to look at these issues in the intelligence community, to give the Europeans some way to at least enforce their complaints. I will talk about, Max Schrems, that's why I call it round 3. He's already blew up the first 2, the data, the shield and the privacy shield and the safe harbor. And he's already said, I don't think this works. This is just the president saying this. That's not Congress. So we'll see. Okay. So I teach the privacy, information privacy class at Loyola Law School. I've been doing that about 8 years, since 2015. And see a lot of bright law students who come in. Part of the class is a seminar class where students present. And this year, I had a student who presented this topic to the class. And I thought it, especially with some of the AI things we're talking about, and because she is so motivated and focused on this, that I said, wait, would you come talk to the group? So, Jade Franke is a third-year law student at Loyola University College of Law, where she's a member of the Loyola Law Review and co-founded the Tech and Business Law Society. This past summer, she interned with the IP and legal operations team at Paramount Pictures in Los Angeles. More recently, Jade earned her Certified Information Privacy Professional, the CIPP, given out by the IAPP for the U.S. She received that certification and plans to sit for the California Bar in July. So a warm welcome for my talented student, Jade Franke.
Thanks, Professor Areaux, for that kind introduction. I am excited to be here this morning, and I'm honored to be sharing my presentation on emotion recognition technology with you all. So, emotion recognition technology, or ERT for short, is the process of identifying human emotions via technology. Most of us have probably interacted with some type of emotion recognition technology in the past, but we may not have recognized it as such. To better understand ERT, I think it's helpful to understand the overlapping technologies involved. So starting with artificial intelligence, this is the ability of a computer to perform tasks commonly associated with intelligent beings. Voice assistant technology, which most of us may recognize as Amazon's Alexa or Apple's Siri. This brings together artificial intelligence and machine learning to recognize our voice and do what we ask of it. Emotion recognition technology then analyzes qualities like facial expressions, tone of voice, or word choice in an effort to automatically detect users' emotional state. So going into the history of emotion recognition technology, traditionally ERT was based off of facial analysis or facial recognition software. However, the trend now has moved more to speech to emotion recognition software. So again, those voice assistants. Emotion recognition technology is based off of the theory of basic emotions, though, which is that everyone essentially expresses emotions the same way. And there's 6 basic emotions being happiness, sadness, anger, disgust, fear, and surprise. Today, there are over 20 emotion recognition APIs. The evolution of emotion recognition technology through the use of voice assistants means increased accessibility to users and increased data collection by companies. Today, an estimated 43% of Americans use that voice assistant technology. So again, that's Amazon's Alexa, even Google Assistant, and as we'll later come to find, Spotify. Of that 43%, the highest percentage of users are 25 to 34-year-olds, though, as you can see from the brackets, other ages are relatively close, and these numbers are only expected to continue to grow through 2026. Today, the emotion detection market is worth more than $21.6 billion, and its value is expected to more than double by 2024, reaching $56 billion. So it's a very lucrative business. To highlight its impact across industries, I have this video.
Comes with a facial expression. And just as we're good at expressing these emotions, we're good at reading them too. But what if emotion could be understood by artificial intelligence as well?
I think AI is getting better and better, more and more refined. Right now, when you look at the technology around, gesture recognition, facial recognition, sentiment analysis, that type of thing, it's really picking up, I think, many emotions.
Artificial intelligence decodes the facial muscle articulations in your face, and it also detects the color changes in your face. And that's what humans use to learn to communicate with other people non-verbally.
We will use emotional AI not just to interact with our customers better, but to interact with our colleagues better, with our bosses better. It's going to be a full spectrum way of engaging with human beings.
The ability to assemble and then analyze, huge volumes of data is a great example, I think, in healthcare around rapid diagnosis and potential variety of treatment options.
Medical applications are absolutely the future, and we can make use of them. And doctors are going to use them to diagnose certain psychopathologies or certain diseases.
We have facial recognition. We have the acoustic technologies. We have the haptic technologies. We can do eye tracking.
We're talking about huge volumes of data and put to very sensitive use in a certain respect. And the ethical norms and the ethical parameters that are applied become absolutely critical.
What we're going to be seeing is a convergence of traditional information conveyance with value-added affective and emotional data conveyance. And those things combined are going to be more powerful than those things separate.
Automation is going to free us up from doing many of the tasks that we do now, allowing us to do other things that are much more important and pressing to solve today's problems.
mankind, womankind is meant to progress. So let's look at an augmentation strategy as opposed to a replacement strategy. And I think, we will all be for the better.
So as I mentioned previously, there are over 20 emotion recognition APIs. I've highlighted a few of the more widely known companies or names that we would recognize, though again, there are a lot more. So starting with HireVue, who I'll dive into shortly with Spotify, but they essentially launched their AI in 2014 that extracts microexpressions, tone, and other variables through video job interviews. In 2015, Facebook was granted a patent for emotion detection and content delivery, which through the use of their webcam, it could gauge viewer ad and video interactions. Shortly after, Apple acquired Emotion, which it does essentially that, tracks viewer attention, engagement, and sentiment. In 2018, Amazon obtained a patent for voice-based determination of physical and emotional characteristics of users through the voice of their voice assistant devices, so their Echoes or Echo Homes. More recently, Spotify obtained multiple patents for various ERT methods and systems, which together could use voice assistant technology to suggest songs and curated content. Other notable APIs or ERT patents include Microsoft's Xbox, which would analyze emotions of a player and give reputation scores based on their emotions. Uniqlo, the Japanese clothing brand, has already rolled out its U-Mood kiosks, I believe in Australia, which could identify customers' moods and recommend an ideal t-shirt. And then more recently, TikTok was accused of tracking users' emotions to sell advertising slots. Now I want everyone to imagine you're in a job interview. As you face the recruiter and answer their questions, an AI system scans your face, scoring you for nervousness, empathy, and dependability. It may sound like science fiction, but these systems are being increasingly used and often without the applicant's knowledge or consent. This is essentially what HireVue is doing. HireVue launched its comprehensive suite of AI-driven talent assessment and video interview solutions in 2014. These structured interviews are typically based on a customized job analysis of a role and ask job applicants to respond to a series of questions in a recorded video. It analyzes various characteristics of the video interview, including applicants' responses, speech, and until last year, facial expressions. The company states that its algorithmic assessments reveal the cognitive ability, psychological traits, emotional intelligence, and social aptitudes of job candidates, and that it collects tens of thousands of data points from each video interview of a job candidate. This includes a candidate's inflection and their emotions. HireVue inputs these thousands of personal data points into predictive algorithms and allegedly determines each job candidate's employability based on that. HireVue markets its recruiting tools as a way to eliminate the hiring biases in the interview process, but hiring algorithms are actually more likely to be biased by default. HireVue represents that it builds algorithmic models for employers based on data from top performers, a method which can perpetuate past those biases. HireVue has conducted over 19 million video interviews for over 700 customers worldwide, and it's most often an automated tool used at the start of the hiring process, so before a job applicant has any interaction with an actual recruiter or human. In 2019, HireVue launched its game-based psychometric test called Emotions, which can be used as pre-hire assessments to measure job-related emotional intelligence. Emotions is modeled after emotion recognition tasks commonly used in business psychology. Participants watch a series of 3 to 5 second video clips to assess their ability to recognize those 6 basic emotions. Emotions then scores the candidate, provides hiring managers with a complete understanding of the candidate's abilities and their perspectives. Later that same year, the Electronic Privacy Information Center filed a complaint against HireVue with the FTC for unfair and deceptive practices. They alleged that HireVue violated public policies for the use of their AI and ethics. This subsequently led to HireVue announcing that it would stop relying on facial analysis to assess job candidates. More recently, a class action was filed under Illinois' Biometric Information Privacy Act. The suit alleges that HireVue illegally collected facial data for analysis. Next, turning to the Spotify patents, Spotify currently leads the music streaming industry with over 400 million users. They likely have the potential to solidify themselves as an industry leader through its recently patented technology that would offer curated playlists based on the individual's emotional state, voice inflection, and surrounding environmental sounds, or what they've coined emotion-based music recommendations. Essentially, you would ask Spotify, play a happy song, and the app would generate countless songs tailored to the listener's emotions. Looking closely at the methods and processes Spotify included in its patent app, a voice assistant device would take in the user's speech and surrounding cues, analyze the metadata, store it, and would then respond with certain content based on that analysis. Content metadata includes emotional state, gender, age, accents, physical and social environment. For example, a response of great may be interpreted as joyful. A response of shucks, or if the user's language was rushed, could be interpreted as angry or sad, which would then prompt Spotify to play a song that would cheer them up. While the metadata collected may appear to be a lot at first glance, most of it's already collected. So the user's gender, age, even their voice. What is new, though, is that emotional state of the user. So Spotify's privacy policy leads users to this Voice on Spotify policy, which outlines the voice data collected and how it may be used. While Spotify hasn't announced the release of their emotion-based music recommendations yet, its voice assistant technology already exists, and you can activate it through the app. Spotify's patents and policy specific to voice may suggest that technology is right around the corner. So with emotional state now becoming part of the data collected by tech, how is this data protected? Traditionally, doctors or medical professionals collected emotional data or that most sensitive data on individuals, and generally those individuals might be subject to HIPAA as a covered entity. Music streaming services are not, similar to what Professor Areaux stated regarding those like swab and genetic testing sites. So without federal regulation, we would look to state statutes, but under state statutes, the definition of covered entity and personal information generally varies. Also, are emotions considered biometric information? Some scholars say yes, that it is considered a soft biometric. However, again, states vary by what they consider to be biometric information. So it leaves users with wondering what is their data is being protected. Is emotion recognition technology good or bad? There could be argued that it offers curated user content, which can lead to increased market effectiveness and better products. In turn, the companies see increased revenue. As a negative, though, AI is built on the idea of basic emotions, and contrary to that belief, humans express emotions differently. They're not all the same. There's also a fear of racial and societal discrimination through the collection and indexing of voice data, including accents and environmental cues. And then last, I think we would all agree that analyzing our emotions is relatively invasive. And with that, I'll leave you all with the thought of emotion recognition technology and whether or not you welcome it. Thank you.
I hope you were as impressed with the technology as we were and had that sort of raise your shoulders, oh, that's really creepy expression as well. So that's all I'm going to say. I'm going to stop so that we can keep on time. And I think I know when I can't really follow with that. I want to leave you with that presentation, the AI issues, and we'll go forward. So we have a break now, and then we'll start our sessions. And in my room over there, we'll have Marsh presenting on cyber insurance. And in here, Daryl, what's the presentation? Book security. Okay. All right. Thank you. Enjoy the conference. Enjoy the summit.